Hello, everybody. Hope everyone's doing well today. My name is Francisco Sirvent. I am the owner and an attorney at Keystone Law Firm, as well as a financial planning advisor with lifestyle planning. And today's topic is, do capital gains disappear at death? And how does that kind of work when you're thinking about your whole tax situation? Taxes are a beast. And here we are coming up to tax season. Hopefully you're nearly done. And I welcome you to this topic. We do these pretty frequently, and if you're here live, welcome. You get the benefit of having an opportunity to do a little live Q&A at the end before we wrap up. If you haven't seen another one that we've done in the past that you are interested in, we do record all of these. They go onto our YouTube channel, which you can find at youtube.com/Keystone Law Firm. Pretty easy to find. And you can see all the different topics that we've done over the last couple of years. There's a lot out there. You're welcome to check those out, as well as if you see a future one that you can't make the live presentation on, you'll be able to catch it over there. It takes us about a week to get them posted to our YouTube channel. So don't feel like you're missing out if you don't get the live version. Also, like I just described, we do record these. So please don't turn your mic on and say something that you don't want to be on the recording. The system will capture it, and then it will be on the recording. So when we get to the live Q&A session, when you, if you want to ask any questions, just keep them generic, keep them in some, word them in some way that it doesn't reveal too much about you that you're not comfortable with sharing on YouTube. So that's just a little bit of forewarning about that. This topic of capital gains is something we talk about a lot with clients because it affects what happens when their family, their loved ones inherit from them. So that's the whole focus of this. I want to give you a little bit of an introduction on how capital gains works, just so we have some foundation, give you some of the concepts of what happens to different kinds of property, different kinds of accounts and investments when they are inherited, talk about how and which ones are affected by capital gains, which ones are not, and some strategy ideas that you should consider when you're thinking about your own stuff, your own finances, your own taxes, okay? I hope you walk out of here. I hope you get to the end of this with a nugget or two, and then you can make the situation better, save a bunch of money in taxes, and don't make a couple really common mistakes we see people make that end up costing their family thousands and thousands and thousands of taxes. One of the unique things, I guess before I get into the content, got to give the disclaimer. This is not legal advice for anybody's specific situation. It's not legal advice. It's not financial advice. It's not tax advice for your specific situation. If you want specific advice, you got to speak with a licensed and qualified professional. You're welcome to reach out to us if you'd like to. So just a quick overview of capital gains taxes. The concept itself is that if you buy something for $5 and you sell it for $15, it's gone up in value, and that increase is now potentially taxable, and it's called capital gains. That's what that is. That's the gain on capital you invested. So if you bought something for $5, sold it for $15, $5 is the capital you put in, and $10 is the gain. It went up by $10. A lot of things are subject to capital gains. So it's not everything in your life, but a lot of things are. Your home, any other real estate investments, commercial real estate. If you have stocks, bonds, mutual funds that you own, either physical, certificates of a company, shares, or if you own publicly traded companies and you own them in your name, you own them in your trust name, those are going to be subject to capital gains when you buy and sell, or I should say when you sell. Investment property, any kind of investment property, collectibles, digital assets, crypto, all that stuff. It's all subject to the capital gains tax scheme in the United States. And, people start to realize that actually capital gains tax rates are lower than ordinary income tax rates, tax brackets. And so, some people start to try to shift their investments over to that category because the tax rates are lower, but they're still going to be subject to some tax, there's tax on everything, right? And so this is one category of those taxes. So if you buy anything at a lower price and sell it for a higher price, it's subject to that capital gains tax. The one thing that's excluded, one big category that's excluded from that, it's not on the chart, are money and investments that are held within your IRA or your 401k, your 403b, some type of qualified retirement program, okay? Because you might buy stock in there and sell it for more. As long as it's within that account structure, that gain on that price is not going to be subject to capital gains. So qualified retirement accounts, when you're buying and selling within the account, those are not subject to capital gains taxes. That's a whole separate tax scheme. When you take money out and you make a distribution to your checking account, that is income tax to you. So it's a whole different tax ball of wax. But there's a lot of things that are included on the capital gain side. You own a small business. If you own anything on the category, you buy art, you buy gold, all that stuff, if it goes up and you want to sell it, there's going to be capital gains taxes on it. There's a big tension between capital gains during your life and what happens after death. During your life, it's pretty standard, and there are exemptions for certain type of property. There are lots of rules and ways to try to get around it during your life, but the standard capital gains tax, the way it works during your life, you buy something and that gives you your cost basis. Okay, now you might make improvements to it and that will increase your cost basis. Okay, so here, house bought for $100,000 ago, probably 30 years ago. It appreciates over time. Great, that's what we want when we buy assets, is they go up in value. So house went up $150,000. That means there's a gain of $50,000. So if they sell the house, it has a gain of 50. So it's just your sales price minus your cost basis, okay? The taxable event is only when it's sold. So far at the federal government, at the federal level, there's no capital gains tax unless you sell it. That's pretty key. There's been some proposals floated. They haven't gotten a lot of traction, but there's been some proposals floated to actually tax capital gains, even if things haven't sold. So just if they go up in value, that triggers your need to pay tax on that increased value, even if you haven't sold it. That hasn't gotten anywhere. So right now, the taxable event is at the sale. Okay, so then you receive what's left after taxes, and there you go. That's the standard how capital gains works. It works on a home, works on stocks, it works on crypto, it works on anything you buy and sell. Okay, that's outside of that qualified retirement account type. The other thing that can trigger a taxable event, okay, so if you sell it, that's a taxable event. The other thing that can trigger a taxable event is if you gift it. So if you gift it to somebody, that's considered a taxable event, but it's treated differently. So this was one of the worst examples I had of a big tax bill that was completely avoidable. This gal had, before they ever came to us, mom, the dad had passed years and years earlier. Mom her health was starting to kind of decline, but nothing serious. She was still living at home, and she heard from somewhere, we don't know, that she might be able to protect her home from Medicaid if she ever needed nursing home benefits by giving it to her daughters. And so she went and recorded a quitclaim deed and gave it to her daughters. But she kept living there because it was her home. And she ended up not needing nursing home or Medicaid. And so she passed away, and the house was now owned by the daughters. There was an issue with something related that the daughters ended up coming in to speak with me after the mom's death. So what happened was, on the left-hand side, you can see over here, is that the mom gave them the property during her life. So what happens when you do that is the daughters now have the same basis in that house that the mom had while she was alive. So mom bought the house for $100,000, if mom bought the house for $100,000 and she gifted it to the daughters 5 years, 10 years, 20 years later, but her basis was still $100,000, then the date of the gift, the daughters now have the house. They own it because they transferred it using a deed. They now own the house, and their basis is what mom's basis was, $100,000. Years later, when mom dies, the daughters want to go sell the house. Well, when they go to sell the house, what's their capital gains going to be based on? It's going to be based on that $100,000. And the house by that point was worth about $450,000. So their gain was $350,000 if they wanted to, and they did sell it after mom died. So $350,000 of gain at a 20% tax rate for capital gains taxes was a $70,000 tax bill at the federal level. And then at the state level, they had to pay Arizona's state income tax. So almost $80,000 in total taxes for that example. So that mom could avoid that Medicaid nursing home issue she was worried about. All of that $70,000 or $80,000 in taxes was completely avoidable. So, and the way you avoid it is by, and we'll talk about the Medicaid strategy in a minute, but the way you avoid it is you leave it to them at death. So by leaving it to them at death through a beneficiary deed, through a will, even if it has to go through probate, through a trust, any of those methods means that it's mom's house while she's alive, and her basis is $100,000 all along, even while the value is increasing. The date mom passes, okay, and the girls inherit the house. By inheriting the house, the tax code says they get a new basis. And that's what the stepped up rules give you. It's stepped up to the value of the house, the fair market value on mom's date of death. So they go to sell it after mom's death, and they sell it for the fair market value, basically. They're going to owe zero in capital gains taxes. And that was a big, big boo-boo. And when I had to explain that's how it was all going to work to these daughters, they were just banging their head against the wall. It's a big tax bill on a house that's about $400,000. It was really frustrating. That stepped up basis at death is one of the key things we make sure people don't screw up when they're doing their plan. Because a lot of people just want to gift stuff, or they want to add a child's name to an account, or put their child on their brokerage account, or put their child on the deed. All these things risk losing that stepped up basis. And this is not just a tax scheme for the wealthy. This applies to everybody, no matter how much money you've got or how little you've got. This whole concept of stepping up the basis at death, or if you make gifts during life and you don't take advantage of it, it applies across the board. So making this kind of mistake for smaller estates is a bigger impact. So think about this before you make any gifts. During your life, you own it, just as a recap. If you do it the right way, okay? So like here, the house is worth $100,000. It appreciates. It's now worth, say, $400,000. That increase is stepped up. You don't have to make any more capital improvements. You don't have to file some special election. There's no legal documents or strategies to implement. You just have to own it yourself when you die. And then it can pass through probate, it can pass through a beneficiary deed, through a trust, it can pass in any number of ways. But as long as you owned it through your date of death, it gets that stepped up basis. Your heirs get that fresh start. They get a whole giant waiver of all kinds of taxes, and they can sell it without worry about, I got to hold back 20% to take care of this bill. And it works on your home, your rental properties, your stock brokerage accounts, crypto, vehicles, art, precious metals. It works on all of that stuff. All of that stuff gets the benefit of it. There's a lot of clients that we've talked to on our financial planning side who have been holding certain stock positions for a long, long time. And if it weren't for the capital gains tax that they would have to pay now, they would not want to own those stocks anymore because they want to diversify better. They want to, they want to move into a different segment or whatever, but they've got so much capital gains built into it that if they sell, they're going to take that big haircut. And we tell them, look, like, you're probably better off writing this thing out and letting your heirs inherit it because they get a step up in basis. It's going to eliminate all that tax, and then they can diversify based on their plans. And so it's a big, giant advantage here. There are a few different kinds of trusts that can either help or hurt when it comes to capital gains. So we're big proponents of owning everything you have in your revocable living trust and using that to avoid probate, to make sure your loved ones have access if you become incapacitated, all these kinds of other benefits we talk about a lot. But there's other kinds of trusts that can also help or hurt with capital gains at death. So a revocable trust, you can make changes to it anytime you want. That's why it's revocable. You stay in complete control. There's nobody looking over your shoulders while you're alive and well. At your death, it is counted in your estate for federal estate tax purposes. So if you're $14 million, if you're over $14 million in total estate, whatever's in your revocable living trust is going to count towards that limit. But the benefit of that is we'll get a step up in basis. Okay, so that's the advantage of owning it in something like your revocable living trust, is you get that stepped up basis. That's the first kind. The second kind is there's in this discussion, there's two kinds of irrevocable trusts. The first one is the type of trust where you are designing it so that you can make a gift out of your account, out of your investments, out of your cash into a trust. And maybe it's the kind of trust where you receive income, your spouse receives income, or it's for grandkids or something like that. And you want to make that gift. It's sort of, I want to make this gift now and get this into this trust for all kinds of different reasons. It might even be for Medicaid nursing home planning. And you set it up in a way so that it still is countable in your estate at death. Okay, you're not doing it for estate tax planning purposes. You're doing it for other reasons. Well, if it's still counted in your estate at death, then it still gets the step up in basis. Okay, that's the two key things of how to figure that out. And so that's one kind of irrevocable trust, is where you're still in some limited control. You still have the ability to access or direct who the beneficiaries are, but you're gifting it because you want to make a gift. The other kind is more for estate tax purposes. Okay, you want to get assets or money or property out of your estate because you're close to or you're over that limit, and you want to start reducing the size of your estate. So you make a gift to a special irrevocable trust. You get it out of your estate. The downside is that when you die, those assets do not get a step up in basis at your death. So it's completely out, but it's not going to be counted against the 14 million when you die, but it also doesn't get a step up in basis when you die. So different scenarios, different kinds of trusts. The first one, the revocable trust, it's where we recommend everybody start. And thankfully, it preserves the benefit of the stepped up basis when you die. So great. Big things to avoid. The first thing to know is your IRAs, your 401ks, 403bs, other kinds of qualified retirement accounts do not get any of these benefits. Even if you funnel it, even if you name your trust as beneficiary when you die, they still don't get this benefit. Okay. There's basically no way around it. Okay. If you want to get a step up in basis, it cannot be in those types of accounts, period. You can pull it out, pay the income tax on it, and then reinvest it in a brokerage account, but you have to pay that tax to get there. It generally doesn't make sense. So just don't count on those getting any kind of step up in basis. The other risk, that's the truth, it certainly has happened within the last 20 years, is the step down risk. So the tax law doesn't say that it stepped up always, right? It is adjusted to the fair market value on the date of death. So if you bought something and the date of death, it's worth less, and they inherit it at that date, well, that's their new basis, sadly. That's just the reality of how the basis adjustment works at death. So then, it's going to go back up, they're going to sell, they're going to pay capital gains tax on it. But that's just the reality of it. The third one is you can't time these things to take advantage of stepping up a basis if it's not really your own property. And here's what, I've had clients ask, hey, I've got some, I'm in my 40s or 50s, and I've got some stock that I did really, really well on. Like, it just was a total lucky thing. I bought it. It shot up to $500,000, and I want to sell it. I want to get out of it. I can't. What do I do? But I heard, the basis steps up on death, and my parents are really, really, really old. Can I just give it to them, let it get stepped up at their death, and I'll inherit it back? And the answer is no. There's lots of rules in the tax code about you can't do things that are just purely to avoid taxes like that. There has to be some other purpose to it. And there's a 1-year look back rule as well. So, find somebody on their deathbed and gift them the property and then get it back. No. So just watch out for that. There are lots of rules around it. What happens if you do that within a year is it just gets added back into the estate and you don't get the step up in basis. Double wipeout. But those are the big things to watch out for. That's the real content for today. I didn't want to go really, really deep into tax law. I wanted to give you guys a high level overview and prompt some thoughts for what you need to think about, what you need to watch out for. And so that's it. It's a shorter one today. If you do want to see our upcoming topics, I'm going to drop it in the chat for you. We've got them at keystonelawfirm.com/events. I can type. And if you want to talk with me about this, I do offer just a quick 15-minute call, and we'll talk about what's happening in your stuff, what your capital gains audit looks like, give you some ideas if there's some things that can be done, can't be done, and help you think that through a little bit. The most common thing that we are talking about with clients on the capital gain stuff is people who own usually it's either a rental property that has appreciated a lot. They maybe have done 1031s for the last decade or 2 decades, and so they've deferred it and deferred it and deferred it. They're like, what do I do at this point? I went out of the rental game. Or like I said earlier, somebody who bought some stock or maybe a portfolio of stock in their brokerage account, and it's grown a lot over 10 or 20 years, and they really feel like they want to reposition things, and they're just not sure what to do. There are some options that can help either eliminate or offset those capital gains in both of those situations. And if that's you and you want to talk about that schedule, using that link I just put in the chat. Otherwise, I am happy to go ahead and open up for questions. I will hang out for a couple minutes if there are any. And if not, we will let you guys off for the rest of the day. All right. Anybody have questions for me? Let me change the microphone settings so you can click your microphone. Let's see. All right. If you want to pop on your microphone, you're welcome to. And I'll tell you real quick, the next webinar date is, just so you know what the topics are. Legacy lockdown from first steps to retirement funds. Michelle's going to be talking about the whole concept of building a fortress around everything you have from beginning to end. So watching, if you have got little kids, what to do there, protecting retirement accounts from creditors, navigating everything from special needs trusts to end of life issues. So that's going to be on April 8th. On April 24th at noon, I'm going to be going through the ugly, and very painful job of what it's actually like boots on the ground to be the trustee after somebody passes away. Just nitty gritty. A lot of people name someone thinking they've bestowed an honor on them, and really they've given them one of the worst jobs in the world. So I'm going to be going through that, and that is on April 24th at noon. We have a few more already booked. If you want to check them out, they are on our law firm's website, keystonelawfirm.com/events. All right. I didn't see any questions come in on chat, or I didn't hear anybody pop their microphone on. So we'll finish up here. Hope everybody has a great Friday. Thanks for joining us.